Welcome to 4-Slide HR, and in this today's session we will discuss on the new labor code which has been passed by the government of India from both the sessions and both the parliaments, their houses, Lok Sabha and Rajya Sabha, and which are ready for implementation from May 1st, 2021. But there is a recent news that it may be postponed for implementation for some time due to some territorial elections. So in this today's session, we are going to learn about the 4 code related to the labor code and labor relation and labor scenario is going to change in India. What is their impact and the benefit and versus for the employee, laborer as well as the principals and the employer. So in this we will cover all 4 labor laws and labor code: the code on wage, code on industry relation, code on social security and code on organization safety and health. Now we are covering the definitions under this code, as we have already understood that these are the codes, their basic fundamental, their added and deleted some new concept in these codes. Now we will share with you the definition, what changes have been done in this new code of labor. The definition of wage under the code, under the labor code is according. First, we are going to discuss about the wages. What are the wages? Wages mean all remuneration, whether by way of salary, allowances or otherwise, expressed in the term of money or capable of being so expressed with mean which would, if the terms of employment expressed or implied were fulfilled, be payable to a person employed in the respect of his employment or work done in such employment, and includes. There is the 3 parts of the wages which has been defined in this new labor code, that are the basic pay, dearness allowances and the retaining allowances. Always this segmentation of the 3 parts, if we go as a whole definition of the wages or salary, there are the 3 parts. One is your basic pay, then is your allowances, and then is your retaining allowances, mean the retirement allowances, etc. So now what does not include in this? In the new definition, with the new definition, there has been some portion excluded from the wages. Any bonus payable under any law for the time being in force which does not form part of the remuneration payable under the term of employment. And second, the value of any house accommodation. If the employer, the organization is providing you any house, so the value of that accommodation, of the supply of light, water, medical attendance or other amenity and services excluded from the computation of wages by a general or social order by the appropriate government, does not included in the term of wage. Then any contribution paid by the employer to any pension or provident fund and the interest which may be accrued thereon, that is also excluded. Any convenience or conveyance allowance or the value of any traveling concession, any sum paid to the employee person to defray special expenses entailed on him by the nature of his employment, house rent, that is also the not part of the wages here. Remuneration payable under any award or settlement between the parties or order of the court or tribunal, and any overtime allowances, any commission payable to the employee, and gratuity payable on the termination of employment, and any retrenchment compensation or other retirement benefit payable to the employee, or any ex gratia payable made to him on the termination of employment not included in the definition of wage. The new definition of the wage is only the basic pay, dearness allowances. Basic pay means the base based on your skill, the basic amount given for the work you have given on, you are doing, you will do according to your skill, ability and knowledge. Then dearness allowances to compensate with the basic essential requirement you have to fulfill, that allowances you have given as the dearness allowances. And then retaining allowances, pay you will be retained for that the allowances has been given, that is come under the new definition of the wages. So many of item I have mentioned here that has been excluded, like house rent allowance is not the part of wage. Understand that one important thing. Overtime was not earlier also the part of the wages. Then commission etc., that is not. Gratuity, that was also not. Then any specific expenses entailed on the any employee in nature of his employment, that is the reversal part, and that is not also the part of remuneration or the wages or contribution you have paid. Here this one thing is you have to understand that the contribution paid by the employer for any pension like ESI and EPF, that is not the part of wage, that are the excluded as the retirement benefit and the social security, because the separate laws has been performed and introduced for the social security. Next, we are going to add, this is provided that calculating the wage under this clause, if a payment made by the employer to the employee under clause A to 1 exceeded one half or such other percent as may be notified by the central government of the all remuneration calculated under this clause, the amount which exceed such one half or the percent of so notified shall be deemed as a remuneration and shall be accordingly added in wage under this clause. If anything which come to the one half mean 50%. One half mean 50% of anything that will be deemed as remuneration and shall be accordingly added in wage under this clause. Then the further that for the purpose of equal wages to all gender, for the purpose of payment of wage, the emulation specified in clause D, F, G and H shall be taken to computation of wages. We will be explain that in later when we will go in one by one reading of all and presenting all the codes to you. Then explanation what come under this definition related to the wage under the labor code, where an employee is given a lieu of the whole or part of the wage payable to him any remuneration in kind by his employer. The value of such a remuneration is a kind which does not exceed 15% of the total wages payable to him shall be deemed to form part of the wages such employee. So it means finally the conclusion is that the total wage paid to him, the 50% of that minimum is come under the wage definition. There is the basic pay, dearness allowances, and the your third one was the allowances for the retaining allowances. Then as per the first provision, exclusion state in clause A to 1 cannot exceed 50% of the total remuneration. This implies wages cannot be less than 50% of total remuneration. Whatever you are giving and providing to an employee, your wage should be 50% of that. It has been defined in the new definition of wage under the labor code. So finally, what will be the salary and the wage come to in account? That is your basic salary plus dearness allowances should be minimum 50% of your CTC, which is called as the cost to company for occurring or own an employee. Generally, dearness allowances and retaining allowances is not paid separately as part of salary. This implies that basic salary should be minimum of 50% of CTC. Why it come to the 50% of CTC? Because when the definition has given the three parts, the basic salary, dearness allowances, and then the retaining allowances, because the dearness allowances and the retaining allowances is not provided as the separately to an employee. So that's why it come to the 50% of whole remuneration you are providing to an employee in your organization. Now then come to the next impression is that if we go to the previous provision, exclusion state in the clause A to 1 cannot exceed 50% of total remuneration. This implies wages cannot be less than 50% of that thing, or 50% of CTC. Then basic salary should be minimum of 50%. It has been mentioned in the previous slide 2. So this is for the emphasis and explanation which you have to understand according to the new labor code, and which are going to implement it from the May itself, even though the date is not finalized as for some territory election is happening, but it is sure it will be implemented soon. So that's why you have to prepare yourself, your organization, you have to assess your ability to implement these codes as soon as possibly, because your basic pay will become 50% of your CTC, which has been mentioned as per the definition. Then we have to understand here what is the importance come out from this definition of the wage under the labor code, new labor code. If payment made under clause A to 1 except tribunal award amount exceed 1/2 or such that percent shall be deemed a remuneration and shall be accordingly added in wages for statutory compliance under the provision of the code. If you are going under the compliances of the statutory compliances under this new code or the labor code, what you have to do in this case, all if there any case tribunal they awarded some amount exceeds 1/2 or such that percent shall be deemed as remuneration shall be accordingly added in the wage for statutory compliance purpose. The wage means the basic wage should be more than 50% of the gross wage. Thereby the employer may fix at least 51% as basic wage plus DA, at the rest 49% can be fixed other component as enumerated in the exclusion clause of wages definition. Thus, bifurcation of the minimum wages should not be done because of the new definition of wage. Now, understand this thing, what is importance here. The first part we can consider later on, but the basic thing is that the wage, basic wage should be more than 15% of the gross wage. If you are deciding a basic gross wage, actually there will be the gross wage which you paid monthly basis, then are the other allowances which you pay on the quarterly basis, then on the annual basis. So those are the amounted, I have to exclude it from that. Then the gross wage come to you, the 51% of that amount you have to decide as the basic wage of an employee, and 49% have to given to the other components. The definition of wage will impose additional financial liability on the employer on the following payment contributions. To understand here, where the definition of the new wage impose the additional financial liabilities on the employer, there will be little bit impact on the employer when they pay out the payment and contribution. First is the quantum of overtime wages payable under increase. The quantity, the amount will be increased when there is the overtime concept available in the organization, as it is guided by the law. So you have to give overtime to a person if he is working more than his schedule and stipulated time. Then quantum of bonus payable may also increase the case of those employees to whom the provision with regard to payment of bonus as contained the Wage Code Act 2019 would apply. The amount of gratuity payable will also be more, as the definition of the wage is the same for all the four codes, because the definition of the wage has been revised accordingly in all the cases which you are paying basis on the contribution and the payment based on calculating on the basic pay that will be increased. It is a little incurring of imposing some additional financial liability to the employer. Now the employer contribution to the provident fund also be increased. ESIC's contribution would come down but coverage will increase. What will be happen here? The ESIC contribution will be come down here. That is the important part. We will be understand this later on how it will be come down, and then we have to think of it. In the case of retrenchment of workmen, retrenchment compensation would also be enhanced because the basic pay has been increased. So here we are going to understand the minimum wage concept, how it will be implies, and minimum wage as notified by the government will be the floor wage earlier and now. If you go to there are basic wage, dearness allowances and the total wage. Earlier, if the people divided, the maximum organization divided their pays in the basic wage and then the dearness, because of the contribution and every calculation done of the basic wage. So now it has been finished that it will become under the whole. If you fixed amount, you divided that in the basic wage plus dearness allowances, then it will become the whole amount. But one thing you have to remember here, that is the minimum wage cannot be bifurcated, that will be fixed as basic wage. Now the provident fund under the new code, what will happen with the provident fund, and we should learn, we should understand that here the particular and the scenario one, we have divided it in the 4 scenarios for international workers. So but you have to understand it on the purpose of organization and perspective of organization. When we talk about the salary and the dearness allowances, for example in scenario 1, that is the 8,000, then you are paying the house rented 4,000 rupees, total wage is 12,000, and your PF contribution as capped at 15,000 would be 960 rupees. 960 rupees. Code on Social Security 440 rupees as minimum wage can't be split. Minimum wage can't be split, so it would be 440 rupees now. And then earlier it was on the basic wage, but now it will be all overall, then it will be applies on all, that it will be 1,414. If go to the scenario level 2, if there is a basic wage is 12,000, then HR you are paying 4,000, conveyance you are paying 2,000, then washing 2,000, total salary will be 20,000 rupees. And in this scenario, what is going to happen? That is what the PF contribution will be decreased as earlier. If the basic is 12,000 rupees, then your payout contribution for the EPF, it will be 14,440. Scenario 3rd, then there is the 12,000 basic, 6,000 rupees house rent, and then conveyance, washing, total salary is 24,000, and your PF contribution will be down now. If there is an international worker whose basic salary is 3 lakh rupees, 150 lakh rupees and 150 in total is 6 lakh, then the previous contribution was 54,000 rupees, but now it will be 36%. So there is, in perspective of the employer, if there is the lower paid manpower, then their amount and their financial impact will be increased. If the highest paid manpower is there, then it will be go down. So here is both sided, but it will be depend for your organization on what level of your salary is there and on the different levels. Now the gratuity, what is the definition and scenario of gratuity under this Social Security Code? If we talk about the gratuity in the previous, gratuity under the Payment of Gratuity Act and the Social Security Code, we have made a comparison over here. The basic NDA, there is the total of the salary is 28,000, because the gratuity for 10-year calculation base, it will be 72,115 rupees only. But now in the new scenario, when the basic wage will be 50,000 rupees or 50% of the total CTC or gross salary, then it will be increased by the then it will be increased by 82,220 2011 rupees as per the new code. Then go to the retrenchment and closer compensation under new industry relation. If you are going to retrenching any employee, as per the Compensation Act under ID Act in 1947 and compensation under the Industry Relation Code 2020. So here is also the compensation will be decreased. Here also 10-year compensation will be decreased, because it earlier was given on the full wage and then it will be decreased as 71,000. Here is some portion and impactful, not so much impactful for the employer perspective, but it will be loose for the employee who are going to be restrained closer compensation and in the industrialization. Now overtime perspective, what will be happen in the overtime in this scenario now? So earlier you are giving the overtime on the basic under the Factories Act and the under Organization, Occupational Safety and Health. So there will be the basic counted as the 50% of your total wage. So understand this, the impact on the overtime will be applies on the employees, it will be cost for them. The next one is the offenses and penalties which will be penalized on the employer. In the first instance, fine of Rs 50,000 to 1 lakh rupees, 10 lakh rupees compoundable, understand this thing. Then subsequent commissions, then fine of 3 lakh to 20 lakh rupees or imprisonment up to 3 years non-compoundable. For employee and employees labor code and the advantage. First we are going to discuss about the advantage of these labor codes in perspective of employer and employees. If you go for the perspective of the employer, the reduction in cost of compliance, the compliance cost has been reduced. Then elimination of high cost of claim to beneficiary has been reduced. When if you are retrenching someone and there is some cases happen, so the elimination of high cost of the claims to beneficiaries. Then provision of one registration license and on return, means if you are in the multiple state, you can get a centralized code and you can work upon the send or the registration and license or returns over there. Then bank-based electronic labor inspection is there preferred, and no physically you the driver and paying something to these inspectors, that will be done. Then before prosecution opportunity to be given to the employer to comply with the provisions. Imprisonment for repeated offenses with 5 years of the first or subsequent offenses. Earlier it was too much. And for employees, advantage is we talking about the section 4 category of the worker need not contribute to Social Security Fund. Means the category of worker need not contribute to Social Security Fund shall be borne by the government. Outreach of scheme to unorganized and the informal sector. 2. First time statutory provision for issuance of appointment letter transparent ways of employee engagement and to be prevent exploitation. Cut-off date for salary disbursement advanced to 7th of consecutive or subsequent month. Recognition of gig work is available there and more formal jobs. Then we go under the Employee Safety and Health Code, the advantage and disadvantage. First, we are going to discuss about the advantage of these Occupational Safety and Health Code. Fewer laws mean better monitoring, easy compliance. One registration, one license, one return, one common authority. One all India license valid for 5 years for engaging contract labor. Otherwise, earlier it was engaging for the every year it has to change. Then the legal provisions strengthened to make employee abide safety norms does not apply to apprentices. Web-based inspection for easy and smooth process. Inspector and facilitator to perform the role of guiding the employee to comply with the code. Challenges. Safety norm proposed would increase the directly and overhead cost in MSME sector. Additional cost for strict adherence to safety norms, then higher rate of penalties for violation in case of death of employee, punishable with imprisonment up to 2 years. Civil court barred from hearing matter under the code. What FKCCI can do? FKCCI means the frontline kicking of the organization can do in these cases. So we have given the name of the FKCCI to make representation regarding removal of the provision related to filling of the complaint directly by the employee or union. Section 52 of the Code of Wage. Simplification of the definition of wage under the Labor Code has been done. Then removal of the threshold limit of 300 for prior permission for layoff, retrenchment and closure. Earlier it is 100, it has become now 300. To ensure that the state government to review the existing labor law, Shop and Establishment Act, Labor Welfare Fund, etc. and Industry Establishment, National and Festival Holiday Act to be harmony with the Labor Code. To make representation to allow women employee worker to work on overnight. To remove consent of women employee to engage them in night shift. So this is all about in this session today, and see you in the next session in the explanation of varied with these new labor codes. Be connected with us and sign up and connect, subscribe this Post-Slide HR for this advancing knowledge on the labor laws and your HR system. We are making and building here the new paradigm of the HRM in this unpleasant time.